have a beautiful picture here.
You? It doesn't have to be the judge.
Oh, well, yeah, he needs to be on, and you can read
Yeah.
it yourself. Let's see, Judge, are you coming in? Are you in?
I have a beautiful picture. That's where,
And you can read it yourself. Judge, are you coming
I
in?
would see.
I hit the wrong button.
Hello.
Yes, sir.
I think you're the one of this. Can you?
Oh, here. There. There we go. Hello?
Yes, sir.
Okay, I can hear you now.
Excellent.
And what case do you have?
I am here on two Capital One Bank cases. This is the 1030, so I have 073 and 101.
Okay, we'll pull those and be with you shortly. Okay, the one in my hand is Capital One versus Janice J. Contreras.
Yes, sir.
And she has been served and given notice. Okay, you may proceed, sir.
Yes, sir. I just want to advise the court that on both these cases, Capital One Bank across all its cases has has taken observation of the fact that COVID has displaced and created havoc with a lot of prior customers, and it has extended a continuance if customers need such. But as nobody has appeared in this case, if the court is happy to proceed, I'm happy to proceed.
Happy to proceed.
Okay. Yes, sir. This matter concerns a credit card account in default. This account was originated between Capital One Bank and the defendant, Ms. Contreras, back in September of 2013. It was subsequently thereafter closed and charged off in August of 2018 for failure to comply with terms of payment. The amount outstanding due and owing as of that date certain is $3,608.62, which is sought by Capital One plaintiff as liquidated damages for said account in default. As noted by the court, this defendant has been duly served. Return of service has been on file with the clerk of the court for sufficient number of days. Although duly served, the defendant has failed to answer or otherwise appeared within the time period required by law. Therefore, we filed our motion for default judgment in this case, providing the court with our non-military declaration as well as the certificate of last known address. In support of our claim, we have our affidavit as to our business records and account for plaintiff, which are inclusive of the credit card statements provided to the defendant at the defendant's address by plaintiff Capital One, inclusive of the final credit card statement identifying the charge off and closure of said account, and the calculated liquidated damages sought as owing in this case, again reflected as the value of $3,608.62. For these reasons and based on such documentation, we ask for the court to render default judgment in favor of plaintiff and against defendant in the amount of $3,608.62. Plaintiff hereby waives recovery of post-judgment interest to be reflected as 0%.
Okay, and I've signed that judgment. And will we email this to him?
We can email it and
Okay.
whatever they think.
What would you like us to email it and regular mail it, or how do you want this?
Oh, email's fine. Would you like me to provide my personal email, or would you prefer to use the email on file that came with the petition?
I need the manager to help me with that. I have no idea.
Yeah, but we have the email where we sent the Zoom link, so I think that should be fine.
Okay, we have an email already, so wherever it is, that's where it's going.
I hate to create duplication. It's whatever the clerk wants. So I usually just try to pose that off to the side.
Right. Okay.
All right. Whenever we're to proceed as to the second matter.
That would be Reginald C. Perry,
Yes, sir.
and you may proceed.
Yes, sir. This is a similar matter concerning a credit card account in default. This credit card account was originated between Capital One Bank, plaintiff in this case, and Mr. Perry, defendant, back in June of 2010. It was subsequently closed and charged off in February 2019 for failure to comply with terms of payment, the account being in breach. The amount owing on said defaulted account at said time being $8,466.40 sought by plaintiff as liquidated damages in this case. Defendant was duly served and personal service and such service. The return thereof has been on file with the clerk of the court for sufficient number of days. No answer having been filed or appearance made by the defendant in this case. We filed our motion for default judgment, providing the court with our certificate of last known address and non-military declaration as to defendant, and also our affidavit as to the account and the business records provided therewith, inclusive of credit card statements that were transmitted to the defendant at the defendant's address by plaintiff Capital One Bank, which is also inclusive of the final account statement identifying the charge off and closure of the account and the amount sought as our liquidated damages in this case for breach on said account being in default. The amount again being $8,466.40. For these reasons and based on such documentation, we ask for the court to render judgment in favor of plaintiff and against defendant in this case, Again, $8,466.40. Plaintiff hereby waives post-judgment interest identified as 0% or to be identified as 0% in this case.
And I will sign that judgment.
Thank you, sir.
And is that all you have for now?
Yes, for 10:30. Yes, sir. I will be back for the 11:30 and the 1 and 2 o'clock.
Okay, well, I'll see you later.
We have a long day ahead of us.
Right,
Thanks, sir.
you're welcome.
Bye-bye.
And I have a Joshua W. Ford.
Yes, good morning, Your Honor.
Oh, good morning. How are you?
Just fine, thank you.
And what cases or case do you have?
I have one on the 10:30 docket. The defendant's name is Joshua Marshall. It's a 0105-JP1.
We only have one.
And you have others for a different docket?
I have two at the 11:30 docket as well.
Okay, but just one for the 10:30?
Yes, Judge.
Okay, and that's Capital One versus Joshua J. Marshall.
Yes.
You may proceed.
Thank you, Judge. This is a debt claim case regarding a Capital One Bank credit card account. We're seeking judgment today in the amount of $1,989.46 plus costs of court. We are not seeking any attorney's
Say
fees.
that amount again?
$1,989.46.
On the default judgment I'm looking at, I know we're talking about small numbers, but it's 1989.55.
I believe there was a credit adjustment made to the account, and that explains the discrepancy, Your Honor.
Okay. And this is the only one we have.
So they would have to pay it.
Would you like me to scratch that out and put your number in there?
Yes, Judge.
Okay, and it's 1989.
Yes, and 46 cents.
1989.46.
Yes, Judge.
Okay, continue, please.
We're seeking that amount plus cost of court, no attorney's fees and no post-judgment interest, Your Honor. This account was opened by the defendant on or about May 2nd, 2008, and was charged off on November 25th, 2017. The last payment that was made on this account occurred on March 31st, 2017. The amount of that payment was $500. We did file this case on December 19th, 2018, and obtained service on the defendant on July 31st, 2019. There's been no answer on file for this defendant and no appearance made on his behalf as well. We did file our motion for default judgment on December 19th, 2019. In support of that motion, we attached a business record affidavit signed by an account representative with the plaintiff, attesting to the accuracy of the balance at time of charge off. Again, that's not reflective of the post-review credit adjustment, so that matches the copy of the final statement showing the balance of $1989.55. We also attached a Service Member Civil Relief Act affidavit showing that the defendant is not in the armed forces, as well as a copy of the Service Member Civil Relief Act affidavit. We would like the court to admit these documents into evidence in considering its verdict today.
Okay. And I will sign that judgment. And what, do we have somewhere to mail it? Email?
No. Mhm.
Okay, we'll mail it to somewhere. Do you need a copy of it? Or?
I don't need one personally, no, Your Honor. Thank you.
Okay. You're excused till 11:30, I guess.
Thank you, Judge. I will see you then.
We'll see you. Thank you. And is that it for right
For now.
now? Okay. So